and the effects of that amendment on the citizens of Virginia. It was approved.
Good evening, everyone. Thank you all for being here. There are many exterior issues that have been discussed about reasons to vote yes for this amendment or vote no for this amendment. Tonight, however, I want to focus your attention on the foundational issue of this amendment, right? Formal definition of marriage. Now, first, I'd like to start off with something that both sides agree on this amendment. Both sides value the institution of marriage. We're here to defend it, and we value that. The other side, they value the institution of marriage and see the value in redefining it. So the question is, why is the institution of marriage valuable? So the value of marriage, ladies and gentlemen, is grounded in the fact that there is a natural order of this world. That male human beings are meant to couple female human beings in order to procreate. It's this fact that makes marriage unique. So I'm trying to say that marriage is about people loving each other. If it's only about love or desire, then marriage, we should extend this definition to include any number of people, any gender of people, anywhere. Think about it. Where would the line be drawn? Would three men be allowed to marry each other, or 3 women? Would a 50-year-old be allowed to marry a 12-year-old? These are issues that would have to come up if marriage was defined only by love. So I would submit to you that the only consistent definition of marriage then must include the natural order of procreation. Furthermore, ladies and gentlemen, marriage between a man and a woman is the only relationship that furthers society's goal, that of continued existence. So therefore, in order to protect the value of marriage, of the institution, marriage must be defined as between only a man and a woman. See, marriage also implies a commitment that is stronger than just a casual agreement of people coming together. See, 2/3 of first marriages last approximately 10 years, whereas most couples that live together leave each other after only a year. So, as Professor Dr. White says, from the University of Chicago, which is a great quote on cohabitation, so we see that no sign that cohabitation is becoming a long-term alternative to marriage in the U.S. It has remained a stage in the courtship process for a temporary expediency, but not typically a stable social arrangement. See, clearly, ladies and gentlemen, the institution of marriage provides commitment within a relationship. So even without children, marriage gives the structure of a man and woman to stay committed to each other. So when we add children into this commitment gives a framework in which a man and woman can not only create children, but raise and nurture them in a stable environment. So studies have shown that children growing up in traditional marriage, studies have shown that children growing up in cohabitating arrangements have lower grades, exhibit behavioral problems, and live in higher poverty conditions than children raised in traditional families. So the marriage amendment, ladies and gentlemen, defines the institution of marriage between one man and one woman, and this is how it's going to affect Virginians. It's going to allow Virginians to define marriage constitutionally, the people of Virginia, how they want, if they vote on this and vote yes. So this is necessary in order to protect the intrinsic value of marriage. In countries where traditional marriage is not protected, there's been a noticeable devaluing of the institution. So namely, more couples are choosing to cohabitate with the results that I shared earlier about the children. These countries include Sweden, France, and Norway. And there's other issues as well. So I pose to all of you a question of this. Is the institution of marriage merely a social convention like that of traffic signals? See, traffic signals and color traffic signals can be changed, and that means nothing. Or does it have a deeper intrinsic value, like that of justice? See, a state cannot just say whether something is just or unjust. A state must be able to recognize justice. Justice precedes that of the state. So is marriage more like this? I submit to you all that it is. That marriage has an intrinsic value to it, defined that by human nature, that only a man and a woman can procreate. that also marriage gives intrinsic value to society, that of commitment. And so for Virginia, ladies and gentlemen, is we bring this amendment will, if passed and voted yes on, will let people be able to say that yes, marriage is this, and be able to protect marriage. And so that, ladies and gentlemen, is why I'm voting yes. And I urge you to as well.
Good evening, everybody. In order to discuss the implications of this amendment, I'd like to first talk about Virginia's definition of traditional marriage. In 1967, when Virginia voters were asked about protecting traditional marriage, 72% of people said that marriage shouldn't be changed from how it stood at that time. 72% of Virginians said that marriage as it stood was the traditional definition of marriage, and that was the definition of marriage that should be protected by government. In 1966, my father graduated from Bridgewater College, and he was a big proponent of not changing marriage from what it was. My aunt agreed with him, and she didn't change her ideas. My aunt passed away in 2002, still believing what she believed when she was growing up, that marriage should be a union between a white man and a white woman. And that's what traditional marriage meant to her. Using that argument, she would state the exact same defenses against trying to change marriage to include interracial marriage. When she would say to me that it just didn't look right for a white man to be with a black woman, or a black man to be with a white woman, it was that idea that there was an inherent difference between those two people that was the foundation of what I believe now. In 1994, when a poll was taken, 20% of the white population still believed that marriage should be between a white man and a white woman, and a black man and a black woman. There should be no intermixing between the two. And in 1991, that was the first time in America's history when a minority of adults were opposed to interracial marriage. So with this idea, marriage is a civil concept. And a civil concept is based on the traditions that are proposed in our Constitution, both the United States Constitution and the Virginia Constitution, which say that all men are created equal, and that they have the right to pursue happiness, and the right to liberty and life. With the constitutional amendment, you can change something from being legal to illegal, or the other way around. But you can't create justice from something that is inherently injustice and inherently unjust. I think this affects us most at George Mason, because we are the generation that's declared to change in the future, and we're dedicated to making sure that all people are equal. As a student senator, a resident advisor, and a peer advisor, I've had to represent individuals in each of those positions who would be directly affected by this amendment, both homosexual students and students in open relationships where they were not married. In these positions, I've had students that were affected both personally and with their friends by issues of domestic violence. And I know that with this amendment being passed, that would directly affect what they were able to do about those situations. And as a student leader, I believe that allowing an amendment like this to pass, where they can no longer defend themselves properly against the injustices committed upon them, is not a proper or effective step to take at this time. I also believe that there is a discrepancy between rights taken away and the protection of a concept. Concepts change over time. And the idea of marriage should be one that protects an institution that's greater than all of us. But that definition doesn't necessarily have to include a certain idea of what is right and what is wrong. So going back to my original argument, in regards to implications of the amendment, in 30 years, what will our children have to say about what we did about this amendment? And what will they say about how we protected equality when we were in college?
In the short time I have to share with you this evening about why I support the marriage amendment, I want to address two main points. First of all, a brief rationale for the government's involvement in marriage at all, and secondly, an overview of what the amendment will and will not do. To begin with, marriage is an institution that precedes government approval. The government only began to regulate marriage after it had already recognized its importance as a foundational part of society. The traditional family unit contributes substantially to the stability of society by providing a framework for bearing and raising children. Because of the beneficial nature of marriage, the government has a vested interest in protecting and maintaining it. Secondly, I'd like to talk about what the amendment will not do. I find particularly interesting the opinion of the State Board of Elections, which is, importantly, a bipartisan group which has studied the marriage amendment. It is noted that marriage in Virginia is associated with specific legal rights and benefits. At the same time, however, there are several comparable rights and benefits which are currently offered by the law to same-sex couples, and this would not be changed if the marriage amendment was passed. And you might wonder why that is the case. And the fact is, the laws already exist. The amendment is doing nothing to change the law. It is merely taking law that is already in place and making it part of the Constitution. We can see this if you look at the wording of the amendment and compare it to Virginia law. I think many of you have handouts and you can do the research yourself and see if the amendment does anything different than what Virginia law already does. For instance, the first part of the amendment prohibits same-sex marriage, and the second part of the amendment prohibits civil unions or any partnerships that would adopt the rights and benefits of marriage. If we compare this to Virginia law, we see that in 1975, the General Assembly passed a statute that prohibited same-sex marriage. They added a part in 1997 that said that any same-sex marriage that was contracted outside of the state of Virginia would be void and unenforceable in Virginia. And finally, in 2004, the General Assembly passed a law that would ban civil unions. So what would the amendment do? It would only take what is already law and make it part of the Constitution. So things like domestic violence laws would still be in place, because people in Virginia currently, they claim protection under domestic violence laws as a household member. So that would be extended to anyone after the amendment was passed. But now that I've talked about what the amendment will not do, and that is change anything that is currently happening, I'd like to talk about what the amendment will do, because I believe that is very important. It will uphold the decision of the sovereign people of Virginia to support the idea of marriage as a union between one man and one woman. It will protect the institution of marriage, which has been proven over centuries to be a stable environment for raising children. I'm not saying that the institution of marriage is not subject to abuse. After studying policy all through high school and college, I understand that no system is perfect. And I also understand that people who have supported marriage have also supported unjust ideas, like banning interracial marriage or not agreeing with that. And so I would definitely say that it's not a perfect institution. But if we look at what it has done over centuries, we can see that it does provide that stable environment for children. When a country legalizes same-sex marriage, we see that marriage itself becomes undermined because it is no longer as significant. If a government takes the criteria that have defined marriage and it broadens them or it takes them away, then it undermines the uniqueness and the significance of what marriage means. Now, the reason that is important is because when marriage is no longer significant or meaningful, people don't have as much of a motivation to marry anymore. And you might say, well, why is that a problem? Well, then that leads to increased rates of cohabitation, which we see in studies is detrimental not only for the married couple, but for children. Let's look at some of the cold, hard facts. Cohabiting couples are twice as likely to report violent arguments as married couples. Additionally, children in cohabiting families have lower grades than children in two-parent families, and children in cohabiting families are 5 times as likely to have behavioral problems. And I think particularly significantly, 20% of children in cohabiting homes are poor. This is twice as high as children who live in homes with married, biological parents or adopted parents. Now, you may not agree with me that marriage is a valuable institution that protects children and that legalizing same-sex marriage would lead to higher rates of cohabitation. But I think we can find common ground on another point, and that is that the Virginia Marriage Amendment will protect the people's decision from being overturned by judges. Any debate about the merits of the current perception and definition of marriage ought to occur in the legislature, not in the courtroom. Any change ought to occur through the democratic process and not through the artificiality of a judge's decision. We can see that courts in the United States have already shown themselves completely capable of ignoring the will of the people and making and changing law without consulting the legislature or seeking their involvement. And I would suggest that by passing the marriage amendment, we would uphold the democratic process and allow the debate to take place where it should, in the legislature, where representatives of the people who support the people's views can debate all the issues associated with this point. And that is why I support passing the amendment. Thank you.
Thank you all for having me here tonight. I wanted to start off by letting you know who the Commonwealth Coalition is, since I'm here as a representative of them. The Commonwealth Coalition is a diverse group of business, civic, and community and religious organizations that have all joined together to oppose ballot question number 1, which you kindly read at the beginning of this debate. And I want to start off by saying that people in the coalition have various views of what marriage should or shouldn't be in the state of Virginia. But the fact of the matter is everyone comes to this table because they oppose ballot question number 1, because it is a radical change to the Bill of Rights of Virginia. All you have to do is read the amendment to see the radical change. It denies all legal rights to unmarried couples in the state of Virginia. And that's unmarried couples. So all of us in the audience know there are 130,000 unmarried couples in the state of Virginia. 89% of those are straight couples. So that is a radical change that denies rights to an entire community of people that has not been dealt with the legislature before. So I also want to talk to you about some of the groups that are members of the Commonwealth Coalition. We have businesses, we have Whittick Combs Communications, we have the Greater Falls Church Chamber of Commerce, who unanimously voted to join our coalition because they feel this amendment does harm businesses. We have the Retail Alliance of Norfolk, Virginia. We have faith communities. We have the National Council for Jewish Women of Virginia, Clarendon Presbyterian Church, People of Faith for Equality in Virginia, Sojourners United Church of Christ, the Maury River Friends Meeting, the Unitarian Universalist Church of Arlington, to name a few. I encourage you all to go to our website and see all the broad faith communities that are members of our coalition. We also have civic and political organizations who have joined our coalition, like groups like the League of Women Voters, who rarely take stances on amendments, or they never take stances on candidates. They are simply about education, but their board looked at this amendment and said that they needed to join the coalition because an informed voter is a no voter, and it's their job to educate voters, and thus they needed to sign up as being against this horrible amendment. We have the Libertarian Party of Virginia, the Democratic Party of Virginia, the Green Party of Virginia. We have groups like Equality Fairfax that work with GMU and around here to work for equality. We have groups like Vote No GMU, who thankfully is hosting this tonight with other organizations. We have the Virginia Sexual and Domestic Violence Action Alliance. We have the Log Cabin Republicans of Virginia and groups like Equality Virginia. So it's an incredibly broad coalition of over 120 organizations who are all working against ballot question number 1 for whatever reason they need to come to the table with. And so you ask, why has this broad coalition joined together? And I want to give you 3 points on that matter. First, because the amendment simply goes too far. This is a radical change to the Bill of Rights. It bans all legal recognition of relationships between unmarried individuals. And Leslie, after me, will talk about some of those legal consequences, so I'll leave that up to her brilliant legal mind. But The members have also joined the coalition because it writes discrimination into the Constitution of Virginia. About 2 weeks ago, we had a great gathering here at George Mason University with Roger Wilkins, who's a professor here at George Mason, and stood behind Martin Luther King Jr. in the American Civil Rights Movement, and said that if Martin Luther King Jr. were alive and a Virginia voter, he'd be voting no on this amendment because it's discrimination. It's a Bill of Rights. It should grant rights to a group of people, not take them away from all unmarried Virginians. And third, the amendment unnecessarily intrudes the government into our homes and private lives. Virginia law very clearly defines marriage and has prohibited same-sex marriage for more than 30 years, as was stated by Sarah. Thank you for that. But this is a radical change, and it's really important that we all understand what we are debating about. So, I also wanted to give you a little personal feel for the folks that I work with on a daily basis, because I think that helps, put this into a proper context. I have great volunteers like Ellen and Victor. Ellen and Victor have lived in Virginia for 30 years together and shared their lives, but for whatever reason, they've chosen not to get married. And they come into my office because they don't understand why their relationship is being targeted by the state legislature. I work with Stacey Rubel of the Virginia Sexual and Domestic Violence Action Alliance, who talks regularly and works on behalf of victims of domestic violence in the state of Virginia. She's talked to folks in Ohio who work on domestic violence issues there, and she says that, they're just warning her more and more about what this amendment will do. They've seen it. They've seen the victims who are affected by this. And they're concerned, and they're, helping her work in Virginia to make sure that victims of domestic violence understand that this amendment is incredibly far-reaching. And I have weekly conversations with faith leaders like David Ensign from Clarendon Presbyterian Church, whose church goes door to door on weekends in their community to talk to their neighborhood about why they, as people of faith who believe in justice for all, are standing up against this hateful amendment. So everyone comes to the table for different reasons, but everyone is united against ballot question number 1 because it simply goes too far. And the real question that we need to answer tonight is why they are targeting, why the second and third sentence of this that harms all unmarried couples in Virginia. And that's something that I hope that they'll enlighten us with. So thank you.
Good evening. I bring you greetings from the Attorney General, who wishing to be here tonight. For thousands of years, on the basis of experience, tradition, and legal precedent, every society has upheld marriage as a unique relationship, inherent and manifest in the most basic and evident truths of human nature. While marriage is recognized by government, the institution of marriage pre-exists the institution of government. Marriage is not a civil concept. Government, in turn, has a vested interest in marriage. That interest is that marriage, the necessary foundation of a family, brings significant stability, continuity, and meaning to human relationships, and transfers basic cultural knowledge and civilization to future generations. Now, I know that there are those who disagree with every point I've just made. Those points, however, should be contested in the branch of government designed to create and implement public policy, the legislative branch. It is not, however, in the legislative branch that marriage is being changed. It has been in the judicial branch with unelected, unaccountable, activist judges imposing their will on society. And for Exhibit A, you need look no further than 3 o'clock this afternoon at the Supreme Court of New Jersey. So the legislature has placed this issue before the people. The process by which Virginians amend their Constitution is appropriately a deliberative process. Careful and thorough consideration should characterize the amendment process. Irresponsible dissemination of misinformation should not. You have the language of the amendment before you. The first sentence of the amendment defines marriage in unequivocal language. The second and third sentences prevent rhetorical sleights of hand that would create marriage by another name. This amendment does not affect the legality of advanced medical directives, protection under domestic violence statutes, the right to dispose property by will, the right to enter contracts, or any of the hundreds of business and personal arrangements that do not purport to establish marriage. It does not violate all legal rights of unmarried individuals. It does not ban relationships between unmarried persons. Arguments that distort the intention of the legislature or raise fears about unintended consequences may score rhetorical points, but they are utterly without basis in the law. Additionally, they are utterly without basis in fact. There are 20 states that have marriage amendments. 12 of those states have language similar to the second and third sentences of the Virginia Amendment. You will hear tonight that the Virginia Amendment is too vague. Listen to some of these words that are already in state constitutions. Georgia talks about benefits of marriage. Kansas, rights or incidents of marriage. Kentucky, a legal status identical or substantially similar to. Louisiana, substantially similar. Nebraska, civil union, other similar same-sex relationship. North Dakota, a domestic union however denominated. Ohio, intend to approximate the design, quality, and significance or effects of marriage. Now, those 12 states have a population combined of 70,682,611 Americans. Out of 70 million plus, there has not been one will set aside. There has not been one deed set aside. There has not been one contract voided. There has not been one advanced medical directive voided because of the marriage amendment. Now you would think out of 70 million people, many of whom are in same-sex relationships, if all these unintended consequences, which have been talked about by the opponents, this flood of litigation which we're going to be hit on because of this vague language, there should be at least one factual case. It doesn't exist, nor will it exist here in Virginia. The Attorney General's opinion says so. The General Assembly's explanation says so. The State Board of Elections says so. That is going to be the first places a judge is going to look. The legislative intent of the state legislature. On the matter of domestic violence, you'll hear over and over again about 2 cases in Ohio. What you won't hear about are the 8 cases in Ohio which have ruled the other way and said that the marriage amendment does not take away protection under domestic violence. That's 8-2 out of 12 appellate courts. Overwhelmingly, the law and the facts show that the unintended consequence argument is a red herring and a scare tactic. Vote for this amendment if you believe marriage should be between one man and one woman. Vote against it if you believe marriage should not be. But do not throw away your vote by believing false, misleading arguments about unintended consequences.
Bravo!
Good evening. I come to you tonight as a representative of the Legal Review Committee of the Commonwealth Coalition. We are over 200 lawyers and legal scholars from across Virginia who disagree with Mr. Johnson's view in the view of the Attorney General on what this amendment would do. A couple of comments initially. First, I'm pleased to be here at George Mason tonight to discuss this. It's a very important debate we're having, and of course, I hope you all know the role that George Mason played in drafting the Virginia Bill of Rights. If you've not read it, I commend it to you. It's a beautiful document. It talks about the liberties of individuals as against the government. Let me read you a little bit. That all men are by nature equally free and independent and have certain inherent rights. The enjoyment of life and liberty, the means of acquiring and possessing property, pursuing and obtaining happiness and safety. And probably my most favorite part, all men shall be free to profess and by argument to maintain their opinions in matters of religion, and the same shall in no wise diminish, enlarge, or affect their civil capacities. This document is revered. This document was used by Thomas Jefferson to draft the Declaration of Independence and by James Madison to draft the Bill of Rights of the U.S. Constitution. We should not lightly amend this document. Those that want to amend it should have to answer 2 questions, and it's their burden to convince us, number one, that the amendment is necessary, And number two is prudent. That it is in the spirit of creating liberty and living in government and not punishing. And that is why over 200 lawyers and legal scholars in Virginia have agreed to oppose this amendment. Let's talk about what it does. The proponents are absolutely right. The first 25 words of this amendment define marriage between one man and one woman. Then there are 60 some odd other words that do more. And it is the do more part that has legal scholars across Virginia deeply worried. It was read to you already, but let me tell you what the problem is here. The Commonwealth and its political subdivision shall not recognize a legal status for relationships of unmarried individuals that intends to approximate the designed quality, significance, or effect of marriage. Okay? This isn't just the statutory rights of marriage. This is a legal, that they cannot recognize any legal arrangement for unmarried individuals that approximates the rights, design, quality, significance, or effects of marriage. So we know there are no civil unions. We know there are no domestic partnerships. And then it goes on to say, and there are also no other legal status. What does that mean? People are deeply suspicious of what this language means. It's not defined in this proposal. It's not defined under Virginia law. Judges will be looking at this as a matter of first impression, and they're going to have to figure out what it means for something to be an effect of marriage. It is not correct to say that the other states that have passed these amendments have passed equally broad, sweeping, untested language. That is incorrect. There are a few states. Ohio passed an amendment that is similar to this, but does not contain the third sentence. That's a very important point. The statute that was referred to about Georgia talks about there being no union between persons of the same sex. It doesn't talk about creating or recognizing legal statuses. That is not correct. The things we are worried about on the Legal Review Committee, first of all, domestic violence laws. The fact that courts in Ohio have been battling for years over this, and it's now gone to the Ohio Supreme Court, is a very important matter. We don't want our domestic violence victims to be tied up in litigation for years over whether or not this amendment voids domestic violence laws. It's a huge concern. Number two, domestic partner benefits. The legislature granted those last year, granted private employers the ability to provide them. The question is, can a court recognize an agreement that provides marriage-like benefits to domestic partners? Big issue about that. Employers all across Virginia are concerned about that. The third piece are contracts. As you may know, many unmarried couples gather together and create private contracts to protect their families, their children, and their partners, to arrange for property and for child custody. The question is whether or not these contracts, these legal arrangements, provide marriage-like rights or benefits, and will a court recognize them? Last, and probably of most concern, are end-of-life decisions, powers of attorney, advanced medical records. These provide benefits that are provided through marriage to people that are not spouses to make end-of-life decisions for their partners. The fact that some state employee might decide that they don't have the power to recognize this, or some judge may say they can't recognize this, and that this may be litigated, is of great concern. Ultimately, the question is, does this create opportunity for mischief? Does it create opportunity for harm? We are concerned it does, and that it goes too far, which is why the legal committee is opposing this.
Thank you all. I can't believe it. On my watch, 1 minute, but it was 30 minutes. That was adequate. Never seen 6 people perform. I can tell you, not academics. No academics would have done that. Okay, I believe we're going to take questions from the floor now.